Good morning to all of you. Welcome to my Jurisprudence class. Friends, we are coming to almost to we are leaping to the last frog of the Jurisprudence. Only important concepts will be discussed, maybe one or two, that's all, almost all completed. So in this video, we are going to discuss the concept of the administration of justice. So whenever I ask you to define what is court, you definitely respond that court is a place where justice is administered. Then what is administration of justice? Please remember, every person is a judge to his own cause. Every human being is a judge for his own cause. You check up. Because మనకు తెలుసు ఏది రైటు ఏది కాదని. బట్ నార్మల్లీ అవర్ సెరిబ్రమ్ ఆర్ సెరిబెల్లం చిన్న మెదడు పెద్ద మెదడు ఒకసారి సరిగా పనిచేయక లేకపోతే లాక్ మనకున్నటువంటి ఈగో సూపర్ ఈగో అంటాం కదా, వాటిలో దెబ్బ కొడతాం అని తప్పితే ఎవ్రీబడి ఈజ్ జడ్జ్ ఈజ్ ఓన్ కాజ్. బట్ హౌ ఎ జడ్జ్ షుడ్ ప్రొనౌన్స్ ద జడ్జ్మెంట్, దిస్ ఆల్సో వీ హ్యావ్ డిస్కస్డ్ ఇన్ డీటెయిల్. The judge should give the judgment basing on justice, equity and good conscience. Justice, equity and good conscience. Already I told you, justice is an elusive aspect. That's why, suppose if any person gets a decision in his favor, he will say, justice is done in my favor. The other person, what he will say? Justice is not done. But still, please remember, what is justice? Justice means being fair, no partiality, totally impartial, and the influence of nobody, no extraneous influence, except the influence of law. That's all. That is what is called justice. Justice should be administered. Normally, you will be under the impression that justice is delivered, but here this is administration of justice. Sometimes you have to give some orders, sometimes you have to acquit the case, sometimes you have to give conviction, sometimes you may have to apply the probation of exercise. Different parts will be. That's why it's called administration. Administration of justice is an important part. So in jurisprudence, administration of justice, according to Salman said, please remember, law may be defined as a body of principles or aggregate principles applied by the state in the administration of justice. The state in the administration of justice, they will apply the so-called body of principles. Law is nothing but the so-called body of principles. And please remember, George Washington of USA, he said, administration of justice is the firmest pillar of the government. Of course, it's a political statement, but anyway, even for the administration of the government, yes, definitely, justice is the firmest pillar. Then, the origin and growth of administration of justice is way back from the society. It developed from with the man and the society. And everybody has to do justice to the society. Justice to the society, is it not? It is one of your fundamental duties. Every individual has to help himself to punish the wrongdoer. That's why now and then the police officers say, every person is a police officer without uniform. And justice, how we are going to do justice, I will tell you. Suppose you know that the police can arrest any person even on the basis of suspicion and send him to jail according to 41 CRPC. But how about the civilians? A civilian also can arrest a person who is committing a non-bailable offense in his presence. But of course, his power of catching the person is very limited. Arresting a person, he has to produce him before the nearest police station as early as possible. But he is a judge, because he has to decide whether the type of offense which is going before him. So please remember, every man is a judge in his own case. And please remember, so why administration of justice is necessary? Suppose if the administration of justice is not there, what people will do? They will try to take vengeance. If A murders B, then the relatives of B will go and attack A and also kill him. This will continue. Previously we used to see in Rayalaseema region all things like that. So And sometimes if a person dies, then compensation or called blood money, it will be accepted and the case will be compromised. But such should not be the case. If justice is done by the court, then it will have its effect on the society. Therefore, the courts should administer the justice. Slowly, the state began to act as a judge to assess the liability of the criminal and also impose the conviction or penalty. Now we'll discuss what are the advantages of the so-called administration of justice. Number one, legal justice ensures uniformity and certainty in the administration of justice because you are followed by legal provisions of law. So you will not go aside, no extraneous influences. This fellow belongs to certain area, this fellow belongs to certain caste, all this, they will not be there. There will be uniformity. And if the evidence is 100% guaranteed, there is certainty for conviction. And impartiality, yes. So that's why yesterday in the class I told you, whenever a judge is there, he should influence only by law, that's all, not by other forces. Impartiality. And in this connection, Chief Justice Coke of USA, he said that the wisdom of law is wider than any man's wisdom. So law is having more wisdom than a person's wisdom. And there are certain disadvantages also because the laws are laws are rigid. They are not flexible. The sections. So it is difficult to understand the laws. So therefore, the administration of justice will become rigid sometimes because they do not see the case. They will hear the case. That's all. They have to depend on the place of the material which was placed before them. They cannot go outside. So therefore, a little bit of rigidity will be there. And sometimes the society will change rapidly, but the justice may be in a snail space. Why? In Disha case, that Priyanka Reddy's case, why all the people asked, they hailed the killing of the perpetrators of the crime because they want speedy justice. So the society is, please remember, is changing rapidly than the system of justice. Then there are so many formalities, formalization and technicalities of justice. Suppose if a person is produced before the court, he cannot be declared as a convict. No conviction can be given to him. They have to observe all the formalities, like supplying the copies, examining him, taking evidence on the other side, hearing the arguments. Then only the judgment has to be given. This is a formality. You cannot go back. So it is laboursome or so people expect much, but it is late. So that is the problem is there. And complex, and definitely it's complicated because you do not know what the judge will come. So even though the evidence is very good, suppose if 100 witnesses say one thing and one witness says the other thing, if the judge believes the other version and says that he acquitted the case, he can't do anything. So please remember, the complex and complicated area of the judgment also, administrative justice also, you have to take into consideration. Of course, the disadvantages, they will be there in every aspect, but you have to look into the facts or advantages of the administration of justice. Definitely, administration of justice is vital in the justice delivery system. So this is what is called the administration of justice. With this, I am concluding. Thank you very much.